Welcome, everybody, to Workshop Wednesday. We're going to give it a moment here to let the attendees trickle in. All right, I'm seeing the number start to climb. So, in case you haven't been to a Workshop Wednesday with Monolith before, what we do is we do a technical forensics presentation every 2 weeks on Wednesday. This Workshop Wednesday is really cool because we have our first guest presenter. We're going to do Q&A at the end of this presentation. So if you have questions, just save them for the end, and then I'll come back on to help manage that. But for now, I'm going to hand it over to Brandon and Matt.
Hey everybody, this is Matt. Hopefully you can hear me okay. If you're new to, like Megan said, if you're new to the Monolith Forensics ecosystem here, my name is Matt Danner. I'm the CEO of Monolith Forensics, and we are primarily a software company. We make a product called Monolith that is a digital forensics lab management system for e-discovery, digital forensics, and cybersecurity teams. So if that interests you at all, if that's something your team might be interested in taking a look, just go to our website, reach out to us. We'll be happy to set you up with a trial and give you a personalized demo. But other than that, today I'm actually on the road. Usually I do these, but I'm on the road today. I'm in my car right now on my way to Houston. But fortunately for all of us, we have Brandon Reim today, who works with the Legal Aid Society in New York, where they provide digital forensic services for the defense in criminal investigations. So I think I've talked to Brandon. I've met him several times at conferences and through various other means in the community. Really smart guy. I think he's going to have some really cool stuff to talk about today. So I'll turn it over to Brandon and let him kind of do his presentation, and then hopefully if you guys listen, please tee up some really good questions for the end here. Anytime we have a guest here, it's really nice for them to take their time to join us and provide us with their insights and their sort of tutelage. So if you think of any question, don't be shy. Please ask. If you want to, we'll even put you on live audio so you can ask it live if you want. Just please contribute to the webinar. It's always useful, especially when we release these recordings later. It's always nice for people to hear from the audience and hear what you guys have to say about things. So with all that said, I'll turn over. Brandon, go ahead, do your thing, and thanks for joining us and doing this for us.
Yeah, thanks for having us, Matt. Um, as Matt had mentioned, I work with the Digital Forensics Unit for the Legal Aid Society of New York. Um, we were given some background. We were founded in 2013. So we were one of the first in-house digital forensics labs for public defenders. They started off with a Manhattan lab, which is where I'm based out of, and we recently, in the past about 5 or so years ago, opened a Bronx lab. So we cover all five boroughs of New York City. We take care of cases all over the gambit of the justice system, from criminal to civil to juvenile. So we really handle a lot of different work. We Sorry, my baby may be loud behind me. I'm just gonna close my door. My dog burst in. Apologies for that. Our work mainly includes mobile forensics, video forensics, social media, cloud. So we typically do cell phone extractions. We will do video enhancement, analysis, compilations. We also handle social media cases where we'll go in and download data from our clients' accounts. We will also do cloud extraction data where we'll go in and get iCloud backups of our clients' data, or WhatsApp or other websites that people use. One of the unique things about our unit is we work closely with lawyers directly. So we have attorneys that are based in our unit that they only handle digital forensics cases. So we are able to talk with them a lot to help us understand the data, and also to have them help other attorneys understand the data. To give a little bit of background of the sort of court system, I'm sure most of us have a idea of what this is being in this line of work, but specifically sort of harping on the defense protections and rights. The Fourth Amendment specifically prohibits government from just searching or seizing anything unreasonably. So that does include our digital data as well. So as you know, I don't know the full audience here, but I'd imagine mostly law enforcement adjacent. You need a search warrant to enter a phone. For us on the defense side, we need consent, which I'll talk about later. The Fifth Amendment, you've probably heard people, oh, I plead the Fifth. That's this amendment. It includes the right to not self-incriminate yourself and also not to just be thrown in jail without a process, fair procedures, a trial, etc. And then the Sixth Amendment will provide protections for those accused of crimes. So when you're accused of a crime, you don't get thrown in jail and then no one ever hears from you again. There are things such as a speedy trial. There's a trial by an impartial jury. You need to be able to understand the evidence that is being levied against you. You need to be informed of the charges. And it also includes a right to have an attorney to represent you in that court. So, as I mentioned in New York, we are one of the public defender offices. Ours is the largest in the New York City area. But there are other public defenders that work in all five boroughs and in the state of New York. There's also federal defenders. There's private firms that will handle. There's other firms that will take pro bono work. So there's ways that you can hire attorneys to help your criminal defense case. So, why are defense practices important? Well, when you are accused of crime, you have an attorney-client privilege with your attorney, so you can talk to them, be open with them, and then they can advise you on your case. So, you're receiving that legal advice from the attorney. Again, going back to the amendments, you understand what evidence is actually being levied against you. And then our attorneys, they have an obligation to represent these clients, obviously within the bounds of the law. So we're not going into court and just making things up. We're using the evidence that we retrieve to show the court our client's version of events. So, like I said, most are probably law enforcement adjacent in here. So you probably see most cases from the prosecution side of things, which are seeking truth, seeking justice for people that have had crimes happen against them. Um, then on the other side, for us, we are advocating for these clients, presenting the evidence on their behalf, potentially getting new evidence to present to the court or challenging evidence that may not be presented in a fair way. So we are, both sort of trying to figure out what really happened in the course of a crime that's been presented to the court. For the digital forensics side of things, we are very similar in the middle. And then on the other sides, obviously, there's the sort of pitfalls and challenges. So for prosecution, again, needs search warrants, needs court orders. Maybe you're getting consent some of the times. But then you're also sometimes limited by the scope of your warrant. So when you actually get that data off the phone, what are you even allowed to search for? What are you allowed to look for? On our side of things, we don't have that challenge of obtaining data from the phone because the client is providing a passcode to us. So obviously, when you bring that to your Gray Key or your Celebrate, you don't have to go through that brute forcing method to try to figure it out, or using things outside of forensics, like a password written down on a sticky note somewhere to try to get into a phone. So they provide us the phone. In that sense, it's very easy because we plug it in and we're ready to go. We don't need to worry about anything else that's occurring in the background there. So what the other part of that is that we have a privacy concern on the defense side. So a search warrant, there's again, no unreasonable search of the phone. But once that search warrant is enacted and the data is extracted, there's no privacy there, right? But the defense side, we have want to be cognizant of what the client wants to show us and what they don't want to show us. Just as a very easy example, the case could just have messages that are relevant. So we don't need to go in and do a full file system extraction all the time to get those. But as practitioners of digital forensics, we know that sometimes a full file system will help us show things that maybe the messages don't. So, for instance, if something was deleted, we wouldn't necessarily see something like a biome or a knowledge C database able to show us maybe a notification of a deleted message in the database. So when we can, we try to get as much data as possible to support the client, but also trying to be cognizant of their privacy in their case as well. So then in the middle here, we have sort of where we overlap. So ultimately, on both sides, our goal should just be doing forensics practices well, following industry standard methods to extract devices and analyze them. So we are doing the same sort of work on our side. We're extracting, we're documenting using chain of custody. We have an evidence management system. We're analyzing, we're preparing these reports for the legal cases, and then validating what our findings are in the methodologies we use, using test data, looking at apps in SQL to see how they work. So we're doing all of those things to try to present the data to the courts. My job is not to, uh, my job is mainly to present this data to an attorney, and then it's kind of up to them if they want to use it and have me testify about it. But ultimately, collecting and analyzing that data is where we would see similarities. So just to give you kind of an idea about like what our workflow in our lab would look like, because I'm sure it differs a little bit from law enforcement. We have attorneys that reach out to us on a criminal defense case. They will tell us what's going on in the case. Hey, I've got this phone. It has messages on it, or it has a WhatsApp conversation. It's going to show this kind of information. I just need it to be extracted and you to write up a report on it. So we will schedule then someone to come down, whether that be a client, client's girlfriend, mom, father, whoever has access to the device, and will bring it to us. So our chain of custody is kind of imperfect in that way, where we're getting the device after the fact always. We're never picking it up on a scene. We're never grabbing it from a search warrant retrieval from the house. So in that way, we still are preserving it the best we can when we receive it. So we follow all the protocols to, enable airplane mode, get all of the data offline as quickly as we can once we receive it, and then do the extraction, whether that's a full file system, a logical, advanced logical, and Celebrate, and bring that data then into our analysis software. So like I said, that consent-based extraction makes this process a lot easier. We get the code. Where we do see some issues is when there's older cases. We have some cases that range from like, 5, 6, 7 years ago. The client's been incarcerated for this amount of time. And then a family member finds a phone in a drawer somewhere and they're like, oh yeah, well, this is the phone we've been looking for. And then client doesn't remember their passcode. So this is the one bar we have, is that we can't obviously get any sort of law enforcement tools to break into any of those passcodes. So it doesn't happen often, but it is a limitation for getting data off the phone. And then a lot of times we, are asked, well, like, what do you do when you do an extraction on the phone? And then there's data on there that's not helpful for your client or quote unquote bad. We still want to inform the attorney of that. We want the attorney to have the best possible picture of what is going on in the case so that when they do present it to the court, they are fully informed and they can fully inform their client. So obviously they don't have to use it in the trial. If they don't want to use it, law enforcement is still able to go out and get a search warrant for that data if possible. So that's kind of a quick answer to that. We also have another facet of our work, which is reviewing data that was provided by the prosecution. So a lot of my work also is just reviewing the data that the ADA's office provides us, like reader reports or magnet forensics report write-ups. So we do this for a couple reasons. One, we may not have access to the phone. So the ADA's office may have gotten in a search warrant and it's in their crime lab, and we're not going to go and do another extraction when the analysts over there have already finished it. So we'll just review the evidence that they already provided us. Um, and then the other reason, obviously, is to provide insight to the attorneys. So we will review this, we'll tell them what the evidence on that phone means, and then they will be able to make, again, decisions about their case. We may even do additional investigation on the phone to see if there's anything that was provided to us that is helpful for our client that maybe was overlooked. And then just reviewing the processes that were used to obtain the data in the first place. Were best practices followed? What is the report saying? What is their expert going to say about the data that was presented? So one of the things that I think is important to sort of try to wrap our heads around is that we're not always necessarily looking for innocent versus guilty. So like I said previously, we're doing forensics investigations to present results on behalf of the client. So what the data says is what the data says. I would hope that if I found something and Matt found something, we would hopefully come to close to a similar conclusion about what that data represents. Um, Obviously, we need to be able to present the data in a way that is easy for a jury to understand. And we want to also show them our side of the story. So when I say that, it may mean mitigation, meaning that yes, maybe our client did do something that was against the law, but maybe it doesn't rise to the level that he's being charged at. Maybe he did do some, or they did do something that was a crime, but the actual circumstances leading up to it, there's multiple parties at fault, or there's another person at fault in addition to our client, which may lessen the charges. So it doesn't always mean that we're trying to say, oh, all of our clients are innocent always. It means that we're trying to do our best to figure out the truth and what happened and to present that to the court to go through. And then obviously, as we know, getting a cell phone extraction is there's so much data to just go through. So even going through it myself or having a prosecution's witness go through it, there's data that could be missed. There's data that we don't even know about. There could be a new app that we've never heard of that Celebrate's never seen that Magnet has no clue of. It's pulled off the phone. It has all the information that one side needs, and we just never know because we don't know to look for it. So there's just so much that can happen. And obviously, again, we get kind of the other side of it where a client might tell us, hey, I was using XYZ. And I'm going to go into some case examples later to harp on that a little bit more. Um, Lastly, before we get into some of those case examples, the tools that we use are pretty much identical at this point to what law enforcement is using. The only exception is like we don't have a gray key, we don't have anything that can password crack, but we are able to get full file systems. That's a recent addition. We weren't able to do that previously. But thankfully, we're able to get those sort of full file systems to get the best set of data. Some of the other sources that we kind of struggle with at the currently are things like iCloud backups. If we don't have the password or client forgot, we can't go get a search warrant for that. Obviously, we only have subpoena power, so we're missing out on some of that content that could be helpful. We also don't have access to like the Facebook law enforcement portal, but we can do downloads of clients' data to support their case in that way. And then just to kind of wrap up this section, some things that like we like to use that if you've never heard of, maybe these are new, but all of the Bergoni suite of like A-Leap, I-Leap, R-Leap are all open sources. We use these to verify the data that we're working with. SQL viewers, I know Matt a couple weeks ago did a presentation on database browsing. All of this stuff is free, and you can learn a lot just throwing your extractions in these tools and figuring out, how these databases work. And we have to do the same thing on our side, which is verifying that data and how it's being shown, whether that's metadata or how a database works or how something's written. And like I said, there could be biome data, that there's always kind of more to what's going on behind the scenes that we can go into. So before I go into the case studies, Matt, did you want to interject anything before I go into that?
Yeah. How often, for your team, the digital forensics guys on your team, how often do you think you guys are testifying at either like hearings or actual trials?
So for video work, it comes up a lot more. I don't personally do a lot of video work, but people on my team do. And it does seem like the video stuff does require testimony more often.
Mhm.
But for like mobile forensics, it's really only a handful of or of times that we do it. Realistically, most of the time, we find something that's helpful for the client. The case doesn't ever make it to trial, and that's mainly why we don't end up testifying.
Mhm.
We may have something like where we'll write an affidavit or we'll go in and talk to, the prosecution together, but it's really not as often that we do. So, I would say a handful.
Okay. No, that makes sense. Yeah. When you guys are doing your review, you mentioned sort of a big part of what you guys do is just reviewing the data and the results provided by law enforcement. Are you guys also, do you include a review of like the search warrant affidavit too, to check for like efficacy and make sure that to look for just things like, okay, they put in the affidavit that they're collecting these things. Does that align with what was actually collected and what was actually searched? Like, do you guys ever do that kind of review, or is that mostly the attorneys on staff that do that?
Yeah, so the attorneys on staff do the actual review of the search warrant. And they will go through and try to, see what was said they were allowed to get, what they did get, what they're presenting. Mainly, we will go through and just see what was on the extraction. So, we're very rarely asked to verify extraction date ranges only because, as we know, when we look at stuff that's brought in through Celebrite, Celebrite might throw in random dates because the date was seen somewhere else. So, there's not a whole lot that we can do to fully limit between a date range. So, our attorneys understand that, our analysts understand that. So yeah, like that would be the kind of stuff we're looking for on our end. But like I said,
Mhm.
most of the time it's being reviewed by the attorneys to
Yeah.
make sure it was done correctly.
Yeah. And I think that's really important too for the law enforcement guys on the call. Um, I think the important thing what Brandon is describing here is that when they look at this stuff, they're fully aware there's sort of these sort of margins, right? Where it's like, okay, nobody can really tell for sure one way or the other on certain things, and you're really kind of looking for like really obvious stuff that's important to mention. So, like, I know when I did defense work years ago, we would review the search warrant affidavit, but all we were really looking for was like, okay, did they actually collect generally what they described they were there to collect? Did they do a search for the stuff that they're generally describing in the search warrant? And just looking for like anything that was just completely out of sync. If they specified a very specific device that they were looking for to collect, and then they end up collecting, 50 other things on the scene that, wasn't mentioned in the warrant or anything like that. That's usually the sort of stuff that we're looking for. So that's kind of why I asked that question, was just to be like the attorneys that are at least looking at it. That's kind of I imagine they're looking for too. Is they're just looking for any like large discrepancies between described and then what was actually conducted during the search itself. Um,
Yeah.
the other, yeah, sorry, go ahead.
No, no, no. That's all. Yeah.
Um, yeah. The other question I had too is how often do you think, I know when I used to do defense work, a lot of the times what I would end up helping the attorney with was I didn't really do much analysis work. It was just more helping the attorney understand what the evidence even was, or even in some cases, if it was a specifically, if it was an investigation specifically around electronic crimes, just helping the attorney understand like the investigation process that police went through, how they came to the conclusions they did about their specific client being responsible for something. Do you find is that a significant part? It sounds like because you guys have attorneys on staff, it sounds like they're probably more up to speed on on the sort of realm of digital forensics than most attorneys off the street. But do you find yourself just basically offering just general consultation to attorneys as opposed to any like direct analysis and that sort of thing?
Yeah, we a lot of the times will get like I said, the disclosure from the DA's office and then sit down with the like case attorney. So we have like the actual digital forensics attorneys and then there's the case attorneys, which are the ones going to court, going to hearings, providing motions. So those attorneys definitely we want to educate them and let them know what this analysis shows, or we will help them understand, what the maybe the analyst notes say about how they obtained the extraction. So in that regard, we do a lot of that because, like I said, the attorneys on our staff are more trying to help with like the legal end of it, and we're trying to explain the technical end of it.
Okay, makes sense. And I think I've got one more question for you. Is there anything just from your perspective as being on the defense side in a lot of these cases? Are there any particular like since we probably have some law enforcement folks here, are there any particular like piece of advice you might give to law enforcement when they, basically under the understanding they should expect someone like you or someone from your team to review the work that they're doing? Is there any like particular piece of advice or um, anything you think they would find helpful to make that process like easier for them? Because I know a lot of it's not as bad as it used to be, but I know a lot of folks in law enforcement they get a little anxious about having defense like review their work and review their stuff. But I'm just wondering if you have any general advice for the law enforcement folks in terms of how they should think about their work in regards to potentially being reviewed by someone.
Yeah, that's a good question. I mean, I think that if we always look at it as like someone else is going to criticize what I'm doing, am I always, am I keeping my notes straight? Am I documenting what I'm doing? Any of that kind of stuff is helpful for both sides. We want to try to be as transparent as possible with what we're doing and not obfuscating anything behind the scenes. So, what was the process to get that extraction? What was the process we used to analyze it? If there's a really weird database, that we had to take out and examine, was that used, how did we test and validate that data? So I think if you look at your work from the lens of like someone else is going to review this, even if they don't have a defense expert on the other side, a jury is going to review it, a judge might review it. So what does my work look like from an outside in? And you can even use yourself as your own critic. If you're looking at it as someone from, that is an expert, what critical lens can you look at your work at? Can you fix any of your processes to make it easier for someone else to see what was going on? I guess that would be my best answer to that.
Well, that's a great answer because that works for everybody, right? Not
Yeah.
just not just law enforcement. That's an incredibly good sort of strategy to use for all of us, no matter if we're doing criminal work or litigation work or anything. I think that's an excellent answer. Sorry, I know I said had one more question, but I've actually got one last question for you because I'm curious about this one. How often is it do you guys ever just like when you're doing your review and you're looking at data, let's say you're confused about something or you have like you're seeing something odd, do you guys ever communicate with the forensic examiners and law enforcement to try to like resolve an issue or try to clarify something? Or what does that communication look like between you and the other digital forensic examiners? Does it not exist, or is there a little bit of back and forth, or what's it like for you guys?
Yeah, that's also a good question. So not any real direct back and forth, but we may point something out that we notice in a, evidence piece and let, the attorneys in our unit and the attorneys in the on the case know. And they may bring that to the prosecution's office and say, "Hey, look, like our guys flagged this. Could you just have them answer this question? Like what's going on with this specific piece?" So yeah, not any direct communication, but definitely has happened. It doesn't happen a ton, but we have, just sent over, be like, "Hey, look, we don't know what's going on here. Can they clarify this?" Or we'll sometimes get reader reports and then Celebrate messes up the reader and we get it and it's blank and we're like, hey,
Yeah.
like, can you guys rerun this? Like, we didn't get anything on our side. So yeah, like that, not any direct, but those are the kind of examples.
Okay. All right. Cool. Well, I think I'm tapped out here on my questions. I'm sure folks on the call will have some later, but go ahead and feel free to go into. I think you had some one or two case examples you wanted to discuss. So,
Yeah, I have a couple. So if we're getting close on time, just let me know. But
yeah.
the So, like I said on that, I mean, that title slide has been up for a bit, but we anonymized these as best we could, just because, they were cases that we worked on. But I just wanted to kind of give an example of some like real world, like these are cases that we did work on, and these are kind of the outcomes that happened. So this first one, client had actually already been arrested for a previous conviction. Some facial recognition technology was used and identified our client as potentially one of the people that could be involved in the case. Um, One of the downsides to facial recognition is obviously that it's just using a face. So our client had some very distinct tattoos that were on their arms. The face admittedly did look very similar, but the surveillance video from the actual incident showed the person committing the crime had no tattoos at all, and it was pretty obvious they didn't, just based off of all the variety of still images and videos that we had. So I didn't directly work on this, but people in my unit did and did some video to zoom in, to take a look, to comparison. And then we also used some HCSLI data. If you're not familiar, it's essentially just cell site records to show activity close to the time of the incident that showed he was in fact not at the location, but was home sleeping. So, two common things that we get on this one are kind of like, well, how do you know he didn't get the tattoo after the fact? Or how do you know, he didn't leave his phone at home, which are fair questions. The tattoos actually, were helpful because the police, since they had already arrested him, had mugshots and tattoo pictures of him, and they were before the incident had occurred. So he would have had them on anyway from that. So that was the kind of proof that he had them beforehand. Um, so obviously this one deals more with like video stuff, not mobile. But that's kind of an idea of, our straight up just miss ID was not our guy, it was somebody else. And the tattoos sort of help prove that one.
Yeah, that's an interesting one because that just highlights just a common problem that's probably going to get worse with AI related tooling that we're probably going to start using, which is the thing I always harp on is like validating your results. You don't necessarily validate your tools, right? I mean, I that's the big thing. Like everybody, accreditation labs, all that, they want you to validate your tools, which is fine. It's helpful, but at the end of the day, like you have to have some way to validate your findings. In this case, this is more of a traditional investigative sense, but you have something that does facial recognition. It identifies two or three potential suspects. It's like, okay, great, but you have to account for what's the margin of error for that facial recognition positive match. It's about knowing how your tool works. Is it a 100% positivity? Like what's the threshold? Is it, a 50%, 60, 70%? And then what's your validate a result like that, right? You do a little extra investigative work to try to place the person in the vicinity. Like just double check, is it even possible for this person to have been there, right? And I think that highlights just I think we're all going to have to deal with as experts in the field is we're going to have to be a lot more critical of the tools that we're using as they try to do more and more things for us, because the more complicated things they do, the higher that margin of error is going to be over time. So we have to be a lot more vigilant in being critical of our tools and the results that we're getting so we can feel, you know, basically feel comfortable that we're getting reliable results.
Yeah, exactly. And attorneys from our unit do a lot with that sort of line of thinking, like you were saying, just validating these findings. We were able to show this, in this case, but it might slip through the cracks on another case. So the next one I have is a phone extraction for video. Um, this one was interesting because the people were in the area at the time, but there was a shot that was fired. The police were alerted. But our guys were there was two people involved in it, actually delivering food on a delivery app. Um, Now the identifying markers that went out, they did match the description of our two people, but it's kind of a generic description, and they were on a vehicle, like a I don't remember the exact type, but the type of vehicle that it was a very common one, so it was kind of just a catch-all. The interesting thing in this case was that when we initially did the extraction for the data of the food delivery app, we didn't get anything. We didn't get anything from the app at all. And then one of our analysts did some testing and found out that the app, if it was online at the time, would actually have the stuff saved down into the database from the app's servers. So what they did was they had done the extraction already, and then they put the phone off of airplane mode, and then did an extraction while the phone was running live, since they already had a copy of the device previously, and then we're able to get some of that information out. So sometimes like doing bad practices, quote unquote, after you do your good practices can sometimes get you different results. The fact that that delivery app, for whatever reason, was only available to get data from it when it was online, I don't know that I can explain. Again, it wasn't my case, but um, we used that, and then there was also some surveillance video from the actual place that these people were delivering that was at the time of or around the time of the shots allegedly being fired. So using kind of those two things, the traditional phone extraction and then the video analysis to put those together, this case ultimately ended up being dismissed, and it was not the people involved. Um, we also have another one sort of with location data, since we are on that previously. Our client was accused of waving a gun outside of his ex's house. And they had history, they had an order of protection against each other. The client said, I wasn't there, I wasn't me. And so we did a phone extraction. This was actually a pretty old case. So if anybody has been around for a bit, when you used to be able to get Google location data off of Google, I think it was like Takeout, that Google was tracking like all of your points of data. They don't seem to have that as often on the online version anymore, but if you have an Android phone, they do seem to still track some stuff in the background. But basically, we were able to put together, movements from his Google location as well as his phone and some other things. And this was actually a pattern of life thing too. So we were able to show that consistently our client went to work at a specific time or around a specific time, used a specific subway train to go up to wherever it was they worked. And he did this, 5 days a week. And putting all of this together showed that on the day that his ex was accusing him, he did not deviate at all from his pattern. We also used, I think, some other tools to verify it was obviously him using the phone. But that also shows just kind of like looking at those patterns, like was anything out of the ordinary that specific day that happened. But this was, textbook what he normally did on any given day. Um, Matt, I don't know. We're at like 11:04. How are we on time?
Good. We're good. Yeah. If you have any other case examples, I think, um, or if you're wrapping up, like we don't have to use the full hour. We can jump into Q&A mode if you're ready for that.
Yeah, I have two more quick examples I can give since I have the slides for them, and then we can do Q&A.
Okay. Yeah, go for it.
All right.
Yeah, these are really good examples, by the way. Very, I think it shows like what I like about them is it just shows like, if for the guys, for the folks that might be in law enforcement, I think this is I've been doing forensics for just about 15 years, and I remember when I first started the. To be fair, the sort of sophistication of defense experts was not great 15 years ago, and I think this presentation with you is just showing the caliber of experts that the defense is getting access to nowadays. So I think if you're in law enforcement and you're watching this, or if you're attending, it's just you just have to think about this now is that you're going to be over time, if you're early on in your career and you're going to be doing this for another 20, 25 years, you're going to just be running into higher and higher caliber experts on the opposing side, both in civil litigation and in criminal cases. So all it means is that you'll just have to, rising tide, rises all boats. So, we're all just going to be getting better at this. So we all have to be vigilant and just be, constantly improving our work and things that we're doing, and just being more and more critical about our own results, so that we can get, just much more reliable and bulletproof results when we walk into a courtroom. But yeah, but please continue. These are great examples.
Sure. Yeah, so the next one we have uses some metadata for videos and another phone extraction. So this one was interesting because somebody that our client was living with had accused him of assaulting them in their home. The reason that it's a big deal in New York is that this was actually a elderly person. So in New York, even like a simple assault, if it's against an elderly person, is immediately upgraded to a felony. It immediately became a pretty serious case. So they had brought us in two damaged devices. And unfortunately, they didn't have a cloud backup. They didn't have anything like that. It was a story of like, oh, like the videos on my phone, they're gonna show I didn't do it. I was the one that was actual victim. So I do a lot of repair personally. I really like doing phone repair. So in this case, we actually just did what I call a zombie phone, which is essentially we took a working good model of this same exact model and we just take the motherboard out. This was an Android. You can't do this with iPhones typically, but we were able to take the Android's motherboard out, place it in a good body that had not changing any of the data because all the data is on the chip, and then able to put it in with a working power button. I mean, the phones were completely destroyed. The screen didn't turn on, the USB port didn't work, nothing worked at all. So we did that for both phones. We, took the logic board swap. So we just took those, threw them in, and then we had working phones. It sounds intimidating, but realistically, it's very simple. It's just kind of playing with screws and making sure you get everything, and you don't break anything when you take them apart. But yeah, we were able to get those working. We got a celebrate extraction for them. And then the videos metadata showed the time and date of the actual incident that the person was accusing of. And it showed that the person, this elderly person, had actually been throwing stuff at our client instead of the other way around. And they actually got hurt within the course of that. So kind of an interesting one there. I like that one because we did some phone repair for it as well. So that was a fun aspect to that one. And then the last example I have is the kind of similar to the one with the Uber or the food delivery app. But this one was that a person was identified as a suspect based off of a previous law enforcement encounter. They, had recognized our client from, this array. He said, no, 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 that wasn't me. I was with my girlfriend at the time. I was taking videos with her and we were getting food. So we actually had to do some phone extractions on the phones. pull some video together, sort of create this like timeline of like where the videos were taken and the photos were taken, and then also use some of the different like local spots they were going to if they had video to kind of show where this grouping was. And eventually they were able to come up with like a pretty good time range. It wasn't, minute by minute, but to show kind of where they were moving around. And when that was plotted out, the actual incident would have been pretty much impossible unless you could teleport, right? Like it was just not feasible within the confines of the transportation that they had available to them to be able to make it to the incident and then over to something else at the time. And ultimately, we were able to present that as their alibi to support his case. Um, all right, so that those are the examples I have.
Hey, Brandon,
Yeah.
I've got a follow-up question now. How often do you think when you guys are working on cases, how often are you guys like the first sort of digital forensic analysts to actually work on the case on either side? Because it sounds like some of these examples, it sounds like you guys might be the first forensic experts to actually work on the case where they're because it sounds like you're pulling data from evidence that the other side just hasn't even seen yet, and you're the first people to put any eyes on it.
Yeah, I mean, we are a lot of times. And again, I kind of go back to that, like we have the privilege of being able to hear what the client is telling us.
Yeah,
So they're telling us, hey, like I did XYZ at this time.
yeah,
So if they never told the police, which they likely didn't, I mean, sometimes our clients talk. But we would like to we hear that from them, and then we go and do our investigation to support that data. In I think I mentioned it a little bit about like reviewing the discovery. We do also get times where, they're like, oh, well, they took my phone, but this is on my phone. And then, maybe it wasn't returned in the discovery disclosure. So we may ask for access to the full image of the device. Um, so yeah, I mean, a lot, I don't know like a percentage, but I would say a good majority of the time we do get a lot of this data before, the police are even aware of it, before we even bring it to the prosecution.
okay, awesome. All right, I guess any other before we jump in the Q&A, any other things, Brandon, you wanted to mention or talk about?
No, I think we have got some like what 10 minutes for Q&A. So if we
Yeah,
want to do that, that's probably a good use of the end there.
cool. All right, Megan, what do you have for us?
Alrighty, we do already have a couple of questions in the chat, so I'll go ahead and go through those. If anybody else has questions, go ahead and either raise your hand or put it in the chat, and we'll get to them as time permits. But I'm going to start with the ones in the chat first. So the first question we had from Michael is, what are some examples of things missed by examiners on either side, the prosecution or defense?
Um, I would say that like specific examples may be hard to come up with on the spot, but just kind of things where you aren't aware that something might exist is probably my best example. Kind of like that last case that I went over where, our client is telling us, hey, this is what I have on my phone. Where obviously on a prosecutorial side or law enforcement side, if they're not talking to you, you may not know that those videos are relevant or what it could be. So yeah, I think like missing context on either side is always something that can happen where you're not sure where to look and then, it ends up being a weird database somewhere or something that didn't look relevant at the time. Would be my best answer to that.
All right, cool. The next question we have is from Drew. There's a little bit of context before this one. He says, in his jurisdiction, the detective on the case is often the one testifying to the data, which is a bit problematic for the state if the defense calls an expert, especially a rebuttal witness who is undeclared. And he was curious if that is the case in New York as well, investigators with limited knowledge offering lay opinion on a technical topic.
So I will say for us, we would be the ones to come in and give an expert opinion if we were going to rebut something. I don't know specifically for the district attorney's office how they always, I don't know the exact like terms that they use for their analysts or examiners or detectives. I do know that they all have units that work in digital forensics, and I believe that they use those people to testify about their, specific reports that they do. I don't think they bring just like anybody in that doesn't have an expert opinion on the case.
Yeah, and also to Drew, to your question, I think again, I'm not familiar with your jurisdiction, but it what sounds like is that the investigator is basically testifying as a fact witness based on the data that they reviewed that may have been extracted from a phone or from a computer. Things like if they're reviewing text messages or photos or videos that they've seen themselves through their own review of the data set that maybe the forensic team provided, then basically they are, especially if they were on scene and were one of the people involved in collecting the original evidence, they can come in and testify, set the foundation for the evidence as it was collected, describing who it belonged to, and then testify to the content that they viewed on the device, whether it was viewed manually or if it was viewed through data that was provided from the forensics team. And then I assume that's probably what's happening in your example, where they would only bring in the expert when they needed some deep technical opinion to be provided to the court on sort of the nature of the data that was examined or reviewed, as opposed to just simple facts about the data, which is like, oh, I saw a text message between person A and person B that said this, right? That's sort of a fact that doesn't require a technical opinion. So that's not uncommon to see that. But again, I'm just guessing as to what the situation is with the way you described it. But I think that's what's probably happening there.
Yeah, and like looking to Dan Peterson's question next, I maybe I should explain like in our specific unit, we pretty much see a case from beginning to end. So we don't take anything like I will do the extraction and the analysis and the reporting. So for the defense side. I don't, it could be different for how the ADA does it. I know that some will have someone that specifically testifies to the extraction method, and then if analysis was done that needed further, they may bring someone else in. So maybe that helps clarify that for us at least. We do it, from beginning to end, on our cases.
Okay, that's all the questions we had so far. We can give it one more minute for questions. If you want to come on and ask your question live over microphone, go ahead and raise your hand and I'll give you permissions to talk and do that.
I
Um,
see one more from Dan actually about reviewing the.
Can you read the question out
Yeah,
for us so we can?
yeah. Are you reviewing law enforcement forensics examiners' written report or vagueness for technical details? When I first started, a lot of reports were fairly generic, but now I'm writing more and more detail and technical reports. I have constantly been changing my reports based off questions asked by defense when testifying. Yeah, I mean, obviously, like when we're looking at stuff, we know what we're looking for. And so if you're including more details in the report, that's, I mean, probably arguably better because then you're able to sort of explain things. But I think too, when you're on the stand, I mean, as long as you have an answer for what you did and you can explain it, that's fine as well. I mean, we don't typically see a ton of vagueness. We do see, what they did and we are able to piece back, what was done. So I don't know if that answers your question or not, but that's what I've got.
I actually have a question. Do you ever interact with the forensic expert on the other side in any of the stuff that you work on?
Not directly. We may like see people at conferences that have, oh, they're from New York, whatever. But no, we typically don't talk directly to them. There's been like one or two times where we may have gone to their offices and we've like said, hey, like, because they're presenting us the laptop that has the extraction for, protective order or anything like that. But no, not typically.
We just had another question come in from Drew. Does Legal Aid Society have a Texas chapter?
I'm sure they have an equivalent of Legal Aid Society type of organization, but no, the Legal Aid Society mainly is just New York, and then there might like we handle New York, and there may be like other organizations that are called like legal aid or legal aid, whatever but they're all sort of separate entities from what we are. There are federal defenders though that handle federal cases all over the place, and they are like they have like what you would say a chapter in different states.
And also, Brandon, even though it's called the Legal Aid Society, you guys are a special organization funded by New York, right? So you're kind of like a pseudo governmental organization, right? Or something like that.
Yeah, like we're part of the funding from New York, so that's kind of who gives us part of the money. We also get, we're a nonprofit, so we can have donations and things like that come in too.
All right, awesome. I think we are out of questions and about up on time, so that worked out really well. So thank you everybody for coming today. Brandon, thank you so much
Yeah.
for presenting for us today. Man,
Yeah.
what an
Yeah,
interesting
thank you.
perspective.
This was a great presentation. Well done. I think this will be a highlight of one of our recordings once we get it posted.
Yeah, especially my dog breaking in.
Listen, slice of life is always good.
Yeah, that
Yeah.
that makes you more relatable, right?
Yeah.
So
Well, hopefully.
you're not just a robot, right?
That's right. Yeah. Wasn't an AI dog.
Yeah. Yeah.
All right. And thanks for having me. And yeah.
Alrighty,
Okay.
thanks everybody.
All right. See ya.
Bye.